Two terrorists in the name of ISIL killed 14 people and wounded 22 others at an office gathering and left behind 3 phones, 2 of which, the cheaper models, they smashed beyond use, and the third was left locked. In any investigation that is done competently, the FBI would try to get access to that phone. It's important that it's a live, ongoing terrorism investigation, but in any criminal investigation, a competent investigator would try and use all lawful tools to get access to that device. And that's what you see happening in San Bernardino. The San Bernardino case is about that case. It obviously highlights the broader issue, and of course it'll be looked upon by other judges and other litigants, but it is about the case and trying to do a competent job of understanding, is there somebody else? And are there clues to what else might have gone on here? That is our job. Democracies resolve these kind of really hard questions through robust debate. I think the FBI's job is very, very limited. We have 2 jobs. The first is to investigate cases like San Bernardino and to use tools that are lawful and appropriate. The second thing, it's our job to tell the American people the tools you are counting on us to use to keep you safe are becoming less and less effective. It is not our job to tell the American people how to resolve that problem. The FBI is not some alien force imposed upon America from Mars. We are owned by the American people. We only use the tools that are given to us under the law. And so our job is simply to tell people there is a problem. Everybody should care about it. Everybody should want to understand if there are warrant-proof spaces in American life, what does that mean? And what are the costs of that, and how do we think about that? I don't know what the answer is. It may be the American people through Congress and the courts decide it's too hard to solve, or law enforcement can do its job well enough with strong encryption covering our communications and our papers and effects, or that it's something that we have to find a way to fix to achieve a better balance. I don't know.
If Apple chose to comply with the government's demand, maybe it does have the technical expertise and time and finances to create such a vulnerability so we can get in and get that information. But let me ask you, what about a small business? I happen to be the chairman of the House Small Business Committee. Wouldn't such a mandate to, say, a small company, a startup, say with 4 or 5, 6 employees, wouldn't that be a huge burden on a small business to have to comply with this sort of thing?
I think it might be, and that's one of the factors, as I understand it, courts consider in passing on an All Writs Act request, the burden to the private actor. How much would it cost them? How much time and effort? And I think Apple's argument in this case is it would take us a ton of effort, time, and money to do it, and so that's one of the reasons we shouldn't be compelled to do it.
Justice Scalia said it's best, said best what I'm going to quote, almost 30 years ago in Arizona v. Hicks, in which he said, "There is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of all of us." I think that stands as a viewpoint that I have to balance when asking you questions. As I understand the case, and there's a lot of very brilliant lawyers and experienced people that know about All Writs Act, but what I understand is that you, in the case of Apple in California, are demanding through a court order that Apple invent something. Fair to say that they have to create something. And if that's true, then my first question to you is, the FBI is the premier law enforcement organization with laboratories that are second to none in the world. Are you testifying today that you and or contractors that you employ could not achieve this without demanding an unwilling partner do it?
Correct.
Under federal law, we do not require technology companies to maintain a key to unlock encrypted information in the devices they sell to customers. Some of the witnesses we'll hear from today argue that if such a key or software was developed to help the FBI access the device used by Syed Farook, it would make the millions of other devices in use today vulnerable. How can we ensure that we're not creating legal or technical backdoors to U.S. technology that will empower other foreign governments in taking advantage of this loophole?
That's a great question. I think that what you have to do is just talk to people on all sides of it who are true experts, which I am not, but I've also talked to a lot of experts, and I'm an optimist.
The FBI has asked a court to order us to give them something that we don't have. to create an operating system that does not exist. The reason it doesn't exist is because it would be too dangerous. They are asking for a backdoor into the iPhone, specifically to build a software tool that can break the encryption system which protects personal information on every iPhone. As we have told them, and as we've told the American public, building that software tool would not affect just one iPhone. It would weaken the security for all of them. In fact, just last week, Director Comey agreed, and I think we heard the same here today, that the FBI would likely use this as precedent for other cases involving other phones. We've heard from District Attorney Vance, who's also said that he absolutely plans to use this tool on over 175 phones that he has in his possession. We can all agree this is not about access to one iPhone. The FBI is asking Apple to weaken the security of our products. Hackers and cyber criminals could use this to wreak havoc on our privacy and personal safety. It would set a dangerous precedent for government intrusion into the privacy and safety of its citizens. Hundreds of millions of law-abiding citizens trust Apple's products with the most intimate details of their daily lives. Photos, private conversations, health data, financial accounts, and information about a user's location and the location of that user's family and friends. Some of you may have an iPhone in your pocket right now, and if you think about it, there's probably more information stored on that device than a thief could steal by breaking into your house. The only way we know to protect that data is through strong encryption.
Mr. Sewell, Director Comey created a dichotomy between this being a technology problem or a business model problem and said that Apple was addressing this as a business model problem. Is that a fair contrast, or is this something else?
It's by no means a fair contrast, Mr. Chairman. I've heard this raised before. It was raised in New York. It's been raised in San Bernardino. And every time I hear this, my blood boils. This is not a marketing issue. That's a way of demeaning the other side of the argument. We don't put up billboards that talk about our security. We don't take out ads that market our encryption. We're doing this because we think that protecting the security and the privacy of hundreds of millions of iPhone users is the right thing to do. That's the reason that we're doing this. And to say that it's a marketing ploy or that it's somehow about PR really diminishes what should be a very serious conversation involving this Congress, the stakeholders, the American people. Just with respect to the New York case, Judge Ornstein last night took on this issue head on, and he said in footnote 14 on page 40, he said, "I reject the government's claim. I find Apple's activities and the position that they are taking conscientious and not with respect to PR or marketing."
If they were to get you to develop that code and apply it and then to crack the 4-digit code to get into the device, once they get in there, they could find all kinds of other restrictions that Apple has no control over, right? With regard to apps that are on the phone, with regard to various other communications features that the consumer may have chosen to put on there. Is that correct?
That's absolutely right, Mr. Chairman. One of the most pernicious apps that we see in the terrorist space is something called Telegraph. Telegraph is an app that can reside on any phone. It has nothing to do with Apple. It can be loaded either over the internet or it could be loaded outside of the country. And this is a method of providing absolutely uncrackable communications. If what happens here is that Apple is forced to write a new operating system to degrade the safety and security in phones belonging to tens or hundreds of millions of innocent people, it will weaken our safety and security, but it will not affect the terrorists in the least.
If Congress were to pass a law, or for that matter, if the courts were to impose a requirement that forcing U.S. companies to provide law enforcement with access to encrypted systems, would that law stop bad actors from using encryption from open sources or foreign sources?
Absolutely not. Absolutely not. And what Apple's product does is it makes encryption easy by default. And so it means that, as I said, the secretary to the chair of the Federal Reserve, the HVAC employee, the chief of staff in your office, of course, your office should be protected anyway, but but the regular person using a phone has the phone secured. What the change, if Congress were to pass a law prohibiting use of encryption on Apple phones, or however you wouldn't say it just for Apple, what it would do is it would weaken us, but not change it for the bad guys.
And if someone purchased a phone from a foreign company, it could have the encryption that we prohibited an American company from creating?
That's, if someone purchased a foreign phone, somebody can just download the app from abroad. They don't have to buy a foreign phone. They can just download the app from anywhere.
We've been talking about statute, but let's ask about First and Fifth Amendment questions.
Right. Good question, Congressman. And bear in mind that what we're being asked to do is to write a brand new computer code, write a new operating system. The law with respect to the applicability of computer code to speech, I think, is well established. So this is a compelled speech by the government for the purpose of the government.
Which is a First Amendment problem.
Which is absolutely a First Amendment problem. And bear in mind that this is speech which Apple does not want to make. This is our position. On the Fifth Amendment, the issue is conscription. The issue is forced activity, forced labor.
You don't have it. You got no way to get it. Therefore, you can't give it, right?
That's correct. If Apple had a box somewhere that we could guarantee, we could assure 100% certainty that anything that was put in that box was not susceptible to thievery, to attack, to corruption. If we had such a place in the world, we wouldn't be here today. Because what we would have done is gone to our customers and we would have said, give us your passwords. We can absolutely 100% protect them. And then if you lose your phone, if you need our help, we can just give you the passcode.
But you didn't do that because you can't guarantee that, which is why you encrypted this phone.
Exactly right. And now the bizarre situation is that essentially the FBI is saying, we all realize it's silly that everybody would give you your password, but instead we want you to build a tool that will get those passwords, and we're telling you you can put that tool in this box.
Are you saying that there is no method that exists now that you could unlock that phone and let the FBI know what is in there?
Short of creating the tool that they have asked us to, we are not aware of such a method. No.
Now, you talk about the cost is an unreasonable burden and the time involved. That's why I ask you, what did it cost to move the cloud? What was the time? And
to be fair, we haven't claimed that the time that it would take to create the tool is the undue burden. Our claim is that the undue burden is to compromise the safety and security of all of our customers.
so it's your position that if you do what the FBI wants to one phone.
Congressman, the answer is very simple. We don't believe this is a one phone issue. We don't believe that it can be contained to one phone or that it would be contained to one phone.